Abimbola.
Yes, please. Good afternoon, everyone, and thank you for joining us this afternoon. My name is Abimbola Adeluwoye, and today we are going to be speaking about navigating infrastructure disputes from dispute avoidance to dispute resolution. This is an initiative of the Telecommunications and Infrastructure Subcommittee of the section on legal practice, which also has the section on technology, media, and telecommunications. The chair of the section of this subcommittee, beg your pardon, is Olumide Oshudolire, and the chair of the TMT committee is Fernandez Marcos Obiene, and hopefully they would be able to join us at some point on this call. Today, we also have the honor of the presence of the chairman of the Nigerian Bar Association section on legal practice, Mrs. Folashade Ali, SAN. She has taken time to join us today and is always present at all our calls. And our presence lends credit to the fact that we are speaking about topics that are very germane to practice as it stands today, and also the fact that in moving forward, leaders always lead by example. And I hope that with our presence here today, we all would get others to also join the subcommittee. It's just about 5,000 naira to register and continue to enjoy the largesse of what we have to offer. Today we have Mr. Michael J. Numa, SAN. He's the managing partner of MJ Numa and Partners as our guest speaker. He's going to be speaking on the topic as referenced, and I hope that we get to not just take notes and just mark this as another point for our MC CED or CPE, but we are actually very cognizant of what we have to learn, and we take it on board, and it can be reflected in the way we practice in our firms, interact with clients, and with other people across industries. So get your papers, get your notepads, get your pencils, or get your biros if you are still of those school, and take down notes and see how you can be improved upon in the next 1 hour or two. To date, moderating is Tolu Oderide, and I hope that we pay attention to him because he's also a very learned person in this regard. And I'm sure by the time the question and answer session starts, we would all be properly primed to, have one or two things in our minds cleared up. So I'm going to hand over to Tolu, who would, if there are any further introductions to be done on our guest speaker today, he would handle that and just provide further information. The section on legal practice welcomes all members. If you're not a member, it's a very good place to join. You have opportunities to grow, to be with people of like minds. And our conference is coming up in April. The early birds registration has been extended, and I hope you take the opportunity to register. It's holding in Lagos at the National Theatre Igomu, a very lovely environment and one that has recently been renovated. So it's an opportunity to also see a major landmark space in Lagos, Nigeria. So over to you, Tolu, now, and I hope the next 2 hours will be one that will be very um, instrumental in forming your career in this regard. Thank you very much, everyone.
Thank
Thank
you
you.
very much,
Please,
Abimbola.
Before Tolu proceeds, Tolu, please apologies. Before you proceed, would like to, as customary, would like to take a very short remark from the section chair who has graciously joined us. I'm sure she always has very, very succinct and powerful words to say at the start of all our sessions. So let us see, please.
Thank you very much. I think you've said it all, actually. But good afternoon once again, and I welcome everyone to today's edition of the Section on Legal Practice TMT series. I mean, we've all been told about the topic. I'm looking forward to hearing more about navigating infrastructure disputes and how we can, from dispute avoidance to dispute resolution. Thank you, first of all, my learned brother, still, Michael Nima. SN for joining, and Tolu, thank you for stepping in to moderate today's session. We've been told about, we've heard so much about our conference. Everyone, if you haven't registered, I'm looking forward to seeing you. There's so much we've planned for the 7th to 10th of April. Be there. If you're not there, you're missing. I can tell you that for free. We have a lot lined up for April. It's an annual conference. SLP is known to organize one of the best conferences in MBA. So without much ado, I just want to encourage everyone who has not done, especially for those who have not registered their law firm. We're launching for the first time a law firm directory in Nigeria. We don't have one. It's for visibility of each and every one of us. And I encourage those that have not, the deadline is round the corner. And you just have to join next year if you don't register now. So please, for those that have not, please do. The link will be sent on the chat group. I wish all of us an exciting and a rewarding session as we all listen to Mr. Nathan Numa, who will be taking us through today's session. Thank you, everyone, for joining, and have a good afternoon.
Thank you so much, Leonard Silk. Good afternoon again, everybody.
Thank you.
I think the previous speakers, Abimbola and Leonard Silk, have spoken extensively about today's session, but let me just add a few things. Infrastructure projects are unlike ordinary commercial transactions. They are long-term, they are capital intensive. They are deeply entrenched in regulatory, business, and political environments. And as a result, the disputes that arise or that occur around infrastructure projects, are rarely, very, very rarely accidental. So they are predictable consequences of complexities and other mitigating factors like changes in economic realities and regulatory assumptions. Today's discussion is not simply about the best tools to navigate those disputes or how to resolve them. It is also about how to anticipate them, how to strategically manage them without truncating the projects as they were or without destabilizing the flow of the project. It is my pleasure to moderate this session. It's also my pleasure to introduce our guest speaker, Mr. Michael Jonathan Numa, SAN. He will be sharing his insights with us on his extensive experience in the dispute resolution space, especially as regards infrastructure disputes in various sectors. Leonard Silk, sir, you're very welcome.
Thank you very much, Tulu, for that kind of introduction. I just turned on my video for a bit, so you'll just see my face for a minute, then I'll turn it back because I understand the network is better without the video. I don't know if you guys can see me.
Yes, we can.
All right, thank you, Madam Chair. Yes, thank you, Madam Chair. See my brothers. This is Falasha, and thanks to the SLP Subcommittee on Telecommunications and Infrastructure for inviting me to share my thoughts on this very important topic. I'm truly grateful. And good afternoon, everyone on this call. I hope my interventions will be useful and it will meet your expectations. All right, I'll just turn off the video and we can proceed accordingly. Now, I must confess that the topic was framed in a very wide context, and we have just 2 hours to unpack a number of things. So I'll try as much as I can to make it as practical as possible by using live scenarios, so we can appreciate the context of the subject, especially with respect to dispute avoidance and dispute resolution within the context of infrastructure projects. So we can maybe appreciate some of the foundational principles that govern this subject matter. Now, like Mr. Tulu had stated, infrastructure disputes are not aberrations like your regular disputes. They are structurally predictable for the most part. And the way these disputes unfold are anticipatory in nature, where whoever manages the project as project advisors can actually anticipate the outcomes of the potential dispute that will arise between the parties. Now, we cannot overemphasize the need for infrastructure in our ecosystem, in our local communities, in our country, in our states, in our region, and in the world at large. So they form a very pivotal part of our everyday lives. Now, infrastructure projects are not ordinary commercial ventures. They are laced with a number of factors because they often involve a sovereign. They are long-term, largely capital intensive, embedded in huge regulatory bottlenecks. The undertakings are there, and it's an intersection between law, engineering, finance, public policy, and all whatnot, ranging from different sectors. So telecommunications, infrastructure, power, generation, distribution, major construction projects, all are incidental to these anomalies. So understanding that basic foundation as the underlying driving factor of how disputes are managed by avoidance and resolved by our different dispute resolution mechanism is very crucial on how we proceed. Now, because of the wide scope of this topic as currently framed, I will try to situate it within a specific dispute which Mr. Tolu was also part of us while he was in our firm, which we handled. It was a cross-border, multinational and multi-continental dispute involving two regional bodies. And because we've actually gone past the arbitration stage and we're now in court, I'm free to actually speak about some of the details. It was a joint border post that involved the ECOWAS Commission and the European Union and a European contractor. So it was a tripartite agreement involving a huge joint border post project. But before we get into that, let us understand some of the major elementary principles involved with dispute avoidance and dispute resolution. Now, these phrases are they're common phraseologies which we use as practitioners in project finance, whether you're transaction advisors or your dispute resolution practitioners within the project finance space, infrastructure space, or construction space. We often hear about dispute avoidance and dispute resolution. Now, when we talk about dispute avoidance, for starters, what immediately comes to mind is the process of trying to avoid pitfalls that would prevent you from potential exposures or liabilities in a contract or in a project, as it were. And this will involve perhaps the negotiation stage, at the stage of consummating the project, the drafting of the contracts or whatever instruments that regulates the project, and the general lookouts for that will reduce the potential liability for whichever party you're advising. The indemnities and the force majeure clauses comes to mind ordinarily on the surface. But dispute avoidance goes way beyond just that. Dispute avoidance is actually a disciplined way of managing the project from conception to commissioning. So it's that disciplined administration of the project, and it makes that instrument an enforceable instrument that regulates your entire conduct in the implementation of that project. So that is what dispute avoidance is about. It goes beyond just the fine templates of the clauses that's embedded in the contract that you're using, because the regulatory framework goes beyond the immediate parties in most cases. Now, because infrastructure projects are largely turnkey in the context we're trying to discuss it, you must understand the underlying objectives of that project. And understanding the underlying objective of that project will enable you to know how to avoid potential disputes and how to manage them when it arises. Now, there are some projects that are inevitable that must result in the disputes. Some disputes are completely unavoidable. They are unavoidable in the sense that a dispute resolution, as opposed to avoidance, is necessary for the long term in certain projects, especially when it comes to syndicated projects that there will be subsequent occurrence. There is a need for you to have some kind of judicial pronouncement or a policy direction that will guide subsequent events that are similar to the ones that you will confront at the early stages. So in that context where there is a likelihood of repetition, it is expedient on the part of the dispute managers to ensure that they have some clear policy direction, either in the tax regime or enforcement regime or any form of regulatory regime that will pose some kind of impediment or a bottleneck. It now becomes incumbent on whoever is managing the project as an advisor to seek some kind of resolution. And that resolution would require a clear policy direction from an arbiter that will guide the subsequent parts of the project's implementation. And in that context, that is where dispute resolution now becomes necessary. The model you now use to get that sort of pronouncement that you seek in our various mechanisms of dispute resolution is dependent on the factual matrix of that particular dispute. Some of them that involves regulators are inevitable that you have to go to national courts. Some of them that are contractual in nature are obvious that you probably might deal with it based on the dispute resolution clause that's provided in the enabling instruments. And the ones that involves large regulators like taxes, you have no choice than to go before either a tax tribunal or a national court to provide clarity as to that enabling regime. Now, those pronouncements are very important on how these policies are shaped. Now, construction projects are inherent in their fashion because they often give room for extensions, variations, and the scope adjustments forming part of their ordinary life cycle. And we know major factors that actually influence these issues that I've stated. It's because change in government is very expedient. Sometimes fluctuation of the currency at the time of contracting, inflation and depreciation of that same currency, like in recent times in Nigeria, devaluation of our currency that has affected major projects. And you can now see disputes arising as to that. And people are trying to pivot differently in order to, one, safeguard the project, and at the same time, try to deliver the project on the part of the contractor or the contracting authority, as the case may be. So I'll try to paint the scenario on the two subheads of dispute avoidance and dispute resolution using the case of the MIMITEC, SRL Interglobal, the ECOWAS Commission, and the European Union. Now, for context, sometime around 2013 and 2014, before the 2015 general elections, there was the scourge of Boko Haram insurgency and insurgency around the ECOWAS region, where there were large infiltrations of small and light weapons coming into the country, reportedly for elections, and some insurgents coming from our borders. Now, intervention agencies like the European Union became concerned to that development in Africa and were happy to provide some kind of aid or respite to curb this surge. The European to support the fight against insurgency within the West African region. And there was an initiative at the European Parliament to set up what is called the joint border post in 3 phases. The first phase was the semi-cracker border, what we call between Nigeria and Benin Republic, the semi-border, to have a joint border post which is technology-driven, highly sophisticated, bomb detective, and all manner of gadgets to actually foresee any potential infiltration of terrorism activities into the region. The lot 2 was between Togo and Ghana, and another one, I think, between Niger and Burkina Faso. I can't remember correctly, but there were 3 different lots. And the approved funds from the European Union appropriation was slated to be given to the regional body for the purpose of that 3 different lots. And because the ECOWAS Commission is the regional body that midwives these 3 different lots and the member states within the region, the ECOWAS was naturally the beneficiary or the donee of that funding. Now, the EU drives that initiative with an ulterior motive. They have an initiative to support their local companies within the European Union coming into Nigeria, coming into Africa, and trying to establish their expertise. And in doing same, there was a financing agreement that was executed between the two regional bodies, between the ECOWAS Commission and the European Union, where they conceded to the fact that all substantial materials, apart from the local content materials like concrete, cement, local labor, and the rest, will be imported from the EU. And there will be a clear flag that shows that these materials were installed by the European Union and utilized by the same for the African use. So that was the way of advertising their own product and indeed their local companies. Now, in that same financing agreement, there was a clear concession on the part of the ECOWAS Commission that had less leverage in the negotiation for the bid process leading to the designated contractor that will be utilized for the project to be midwifed by the EU rules, strictly by the EU rules. So there was no opportunity for African companies to actually bid favorably because they were not conversant with the EU rules. And most of the EU rules provide for some regional framework within the European Union, and it was very difficult for them to actually bid. So to that extent, Mimitech SRL was the designated for that particular project to deliver on the joint border post to meet the underlying objective of that. Now, mind you, the designated funds of $40 million, 40 million euros, I beg your pardon, was to be utilized within a limited period of 15 months. Otherwise, it will revert back to the European Union Parliament and they will vote for it the way they deem fit, depending on their priority at the material time. If they consider the project expedient to be expanded, they will extend same and revote in their new appropriation within the Parliament. But if it's no longer expedient, they will now dissipate the money to something else, and we've lost out of that project. So there was the need for certainty as to time, certainty as to the project, certainty as to cost implication, and certainty as to a number of things, which gave room for little or no variation whatsoever. The materials to be used in the implementation of the project will be brought in once. The local taxation will be sorted out in accordance with the tripartite agreement entered between the parties, and every other enabling materials will be on ground, clearly spelled out. That is why we said this sort of project are structurally predictable. You anticipate every potential pitfall that would come out from same. So in this particular regard, the ECOWAS Commission was designated as the contracting authority, while the EU was designated as the financing authority, and the contractor was designated as the contractor, and the contractor became the claimant when the dispute arose. In that same project, the ECOWAS Commission had very little leverage in negotiating the terms because we're barely just receiving the monies as donees, and the monies was gratis, more or less. There was no consideration on the flip side. So the project was essentially driven by the Europeans, and we could not determine it. The only saving grace on our part was that the choice of law was designated to the law or the seat of the contracting authority. And because the ECOWAS Commission is headquartered in Nigeria, the Nigerian law became the enabling law. And that gave us some advantage in the course of the proceedings. Now, was that contract properly managed? We'll get to that phase, but I can tell you till today, for those who travel within the ECOWAS region, there is no joint border post. That project never came into fusion. As huge as the project is, as innovative as the project was, as laudable as the initiative, which is the underlying objective of the project was, that project never came into fusion. Our borders are still porous. There is no joint border post that is electronically driven, and nothing happened because of the mismanagement of that project and our inability to avoid the disputes that were clearly predictable, and how the dispute was eventually resolved by way of, as a matter of fact, the dispute is still on. We are at the Court of Appeal right now. So let me start from the basics as to dispute avoidance. At the time of contracting, to my mind, and which was clearly stated by the tribunal in most parts of the award, was that the ECOWAS Commission had very little leverage. And what sparked the dispute was very simple. The obligations of the ECOWAS Commission was to authorize the payment. Now, these monies were not given to the ECOWAS Commission in cash. The ECOWAS Commission will identify the project scope, which the bidding was done by the EU, and the ECOWAS Commission was to confirm levels of implementation and forward the invoice to the financing authority, who will pay directly to the contractor that is in Europe. So at no point in time, for obvious reasons, which is an experience from the past, where these donor funds are being misappropriated by member states or the donees. So they came up with a mechanism where the monies will be paid directly to the contractor chosen by them. For reasons of quality control, for reasons of misappropriation, for reasons of fear of timeless delivery, they decided to take that model. And the ECOWAS Commission, cap in hand, accepted the model without any form of variation in the terms that was proposed. So on that note, their obligation was limited to confirming payments at every milestone of the deliverables. And mind you, this is to be delivered within the period of 15 months. So there was a first payment tranche without any sort of disagreement between the parties. The ECOWAS commissioned the first payment and it was made. They also confirmed the second phase and it was made. At the third phase, when the contractor completed same to install and commission subsequently, there was a challenge as to payments, despite the fact that the ECOWAS Commission had authorized the payments for onward disbursements by the EU, being the contracting authority. The EU decided to withhold the funds, and they withheld the funds on the grounds that the contract did contemplate a right of set-off. Now, interestingly, the right of set-off was at the heart of that dispute. The right of set-off arises where the contractor, who is domiciled in the European Union and a major contractor for the European Union, defaults in any of their projects around the world, they have a right to exercise the right of set-off without recourse to the contracting authority. So the project was meant for the benefit of ECOWAS. ECOWAS is the contracting authority on the face of the contract. The financing authority has the powers to determine how the project is implemented. They determine the payments, the milestones subject to confirmation by the contracting authority, and they decide to withhold or terminate the contract as they deem fit because they are the owners of the monies. At the stage of contracting, the management of the project was poor because the ECOWAS Commission had little leverage. Now, when they exercised their right of set-off, it was with respect of a completely extraneous contract that happened somewhere in the Caribbean, in Turks and Caicos, where the same contractor, Mimitech, had some defaults in the execution of that contract, still funded by the ECOWAS, by the European Union. And essentially, because of that project that has no bearing whatsoever to the contracting authority that is supposed to be the donee, they withheld the payment. And they withheld the last milestone of 6.1 million euros, which was going to lead to the commissioning of the joint border post. And when the defaults as to payments was notified to the ECOWAS Commission confirmed that we've authorized payment, and I see no reason why these monies have not been paid and why you've not been able to complete the project. The EU asserted their right of set-off, which is contained in the contract. At the stage, the in-house counsel from the ECOWAS region never knew that there was such a provision because they were more interested about holding the funds as against knowing the implications of the monies they were receiving. And they refused to actually release the monies on the basis that the contractor has actually defaulted in a similar project somewhere in the Caribbean. That resulted in a dispute. Letters exchanged between the contractor and the contracting authority. The possibility of managing the dispute at that stage was impossible because the financing authority insisted they must go through with their regulations as provided in their EDF. EDF is the European Development Funds regulation. And because they can't tolerate defaults by any of their contractors within their projects across the world. So they must implement that clear terms of the project. The ECOWAS Commission never envisaged that provision, despite the fact that it was contained in both the specific provisions and the general provisions that culminated into that project in the first place. So what did they get wrong? They never envisaged how to avoid that, and there was no boilerplate clause that could actually safeguard them or exonerate them from that. The EU has guaranteed payment, and the EU has said we were reneging from that because someone is owing us somewhere and we have to offset that liability from the subsequent project that they needed. Memetech, of course, asserted that a breach has occurred and a dispute has arisen, wrote pre-action letters to both the contracting authority and the financing authority. The financing authority, as usual, who has protected themselves by anticipating this sort of dispute, said, well, we're not a party to the contract. We only provided funding. ECOWAS, you're the contracting authority. We've actually offset the liability owed by the contractor from the monies he's entitled to. Hence, we cannot help you at this stage. ECOWAS was caught cap in hand, either to pay from their own resources or they deal with the disputes. So when the dispute got to court, of course, the court was supposed to grant some interim measures in order to stop any contractor from coming to the site, but the judge in his wisdom referred the matter to arbitration in accordance with the arbitration contract, and that gave rise to the constitution of a tribunal, party appointed as envisaged in the original contract. So we were unable to avoid the disputes because of how the contract was structured. That is what I mentioned originally. It goes beyond the drafting of the contract. It is the implementation and to envisage the predictability in terms of the structuring of that original project. The project was clear, the objectives were laudable, the timeline sets were certain, there were no variations, provisions for price differentials. The force majeure clauses did not provide a wide scope because the objectives were very clear in the minds of those bringing the money. And they were unequivocal in the provisions that inserted that if you fail to utilize this money within a particular period, which was 15 months, the money goes back to Parliament and it will be voted for. And if Parliament feels the need to actually vote the money for a different project, so be it, you lose out of it. So the need for prudence on all players were very important. But we ended up seeing that our own African counterparts could not have been able to manage that or avoid that because they were not part of the negotiation stage. It was more or less an asymmetric contract to say, take it or leave it. We're giving you money. If you don't accept it, you let it go. And that was a shame, by my estimation, on how that project was managed until today. It never came into fusion. Now, at the stage of the dispute resolution, there were a number of factors that played out. The first approach was to see how typically lawyers would just file all manner of processes to see how the claim can be dismissed in limine, either by way of preliminary objection or look for one technical objection to actually enable the tribunal to rule summarily and the matters are resolved. But we had to look at it from the underlying objective of the project. What do we stand to gain? Is there a possibility of some compromise for this contractor to go back to site and deal with it? Of course, in my opinion, there were a number of options available to both the EU as well as the ECOWAS Commission. But parties were adamant in the approach that they adopted, and that gave rise to where we are today as a result of that. Now, one of the major issues that played out at the stage of dispute resolution, especially at the pretrial stage, was the inability to have these two regional bodies that signed what is called a financing agreement that was precursor to the tripartite contractual agreement for the supply and installation of the joint border posts to come to a consensus. And the inability to reach that consensus was because one party had a stronger bargaining power over and above the other party. And the only advantage that we had was the choice of law. And the choice of law was couched in the general provision in such a way that was even deliberate on the part of the EU that except the EU is the contracting authority, the applicable law would be the law of the states of the contracting authority. And in this context, the contracting authority was designated to be the ECOWAS Commission. The second aspect that was advantageous to the contracting authority was that local content laws of the contracting states will also be implemented. So they were prevented from bringing the laborers, the local artisans to Africa. And that was the only advantage. The residue of the materials, substantially, maybe 75% of what was utilized, were brought in from Europe and clearly flagged. Maybe cements, iron rods, and a few things that would have been cheaper to procure locally were the materials that were procured locally from local vendors, which were still sought by themselves, not using the ECOWAS Commission to midwife that process. So the ECOWAS Commission had very little room to navigate the avoidance of the dispute. So several interventions were made by the Council of States, which is the highest ranking body in the ECOWAS region, to interface with their European counterparts to see if there could be some amendments and extension. But because of the EDF's strict provisions, those entries were declined by the EU. The contractor, on the other hand, could not wait, had issued notice of arbitration, and the tribunal was conveyed. At the stage of exchanging pleadings, we also sought to find some kind of middle ground to see how they could be compromised for the purpose of still meeting the contract. At the time, we had just 3 months left. The EU took a very extreme position that by their rules and by judicial decisions in Brussels, they cannot be held to be a necessary party to the contract. They merely give money. And the configuration of the contract called one party as a contracting authority. So all the infrastructure that was contemplated for the joint border posts between the 3 different lots could not go on because they were not a contracting authority and they withheld the monies to that effect. So please deal with yourself. At that stage, we invited the tribunal to the fact that the Brussels law or the EU law by extension was not the applicable law, owing to the fact that the choice of law was the law of the contracting authority, and the contracting authority is domiciled in Abuja. So the Nigerian law becomes the applicable law. And by the configuration of the contract, it was a tripartite agreement having endorsed or guaranteed to pay the sums. So the heart of the dispute that revolves around the set-off that triggered the legal injury complained about by the contractor was occasioned by the actions of the EU, making them a proper, necessary, and essential party for the resolution of the dispute. So there was no way they could rule on that, and they couldn't run away from that. They also asserted, amongst other things, that the tribunal lacked jurisdiction to actually determine the reference as it concerns them, that it was a business between the contracting authority and the contractor. We now had to go back in the course of resolving this dispute to the original contract that midwifed this, which was the financing agreement. Mind you, the financing agreement was between the 2 regional bodies, where they expressly undertook that they were going to take care of every financing that has to do with EDF developmental projects within the ECOWAS region. In the argument, in the course of pleadings, they contended, amongst other things, that that contract is extraneous to the contract that provided for the arbitration agreement. And the scope of the reference does not include that particular contract. Hence, we cannot import the provisions of that contract to this. But that was the beginning of the relationship between these 2 regional bodies. And there was no way that the tribunal would have severed that particular instrument from this one. So we contended at the tribunal that was the beginning point. And if the tribunal was to appreciate the necessity of having ECOWAS as a party, the tribunal must look at the underlying objective of the project and the instrument that bettered the project in the first place, which was the financing agreement. In that regard, the contracts had to be looked at as a syndicated contract alongside what the parties represent from their respective obligations. So we were able to convince the tribunal to see it in that regard, despite the strong opposition by the lawyers from the EU, and which were all foreign lawyers. The tribunal ruled at the preliminary stage that Nigerian law was applicable law. Hence, there was a need for local counsel to be engaged. So they engaged one of the big margin circle law firms in Nigeria, Olaniwa Ajayi. I'm sure some of their associates or members of staff are on this call, who provided local advisory on Nigerian law support to these foreign lawyers that were dealing with. The tribunal, upon reaching that conclusion that it was Nigerian law that is the applicable law, came to a further conclusion that by the configuration of the parties and by the jurisprudence in our contract laws in Nigeria, they were necessary parties to the dispute, and their actions was what triggered the legal injury complained about by the contractor. Now, on our part, as the contracting authority faced by two Europeans that obviously had extreme agendas, one was pushing to get his monies, having made substantial commitments towards the implementation of a contract, and was not interested in offsetting the liability that was set off from the different projects. And I've argued that that project is different from this one and severable, despite the extended scope of the set-off clause that said by any means necessary and without recourse to anyone, including the contracting authority. And in this particular case, the contracting authority was not informed that they were going to exercise that right of set-off. The tribunal ruled that the set-off clause was valid and it was properly invoked under the prevailing circumstance, despite the fact that recourse was not made to the ECOWAS Commission. However, the tribunal acceded to the counterclaim that there was a breach on the part of the contractor to the extent that the contractor did not meet the timelines that were originally envisaged. Now, on the flip side, the contractor argued that there were a number of intervening events, which include demurrage arising from the inability of the contracting authority to provide them tax waivers for the materials that were brought in from Italy, which were originally agreed, but absence in the contract. Apparently, by waiver by conduct, extempore by conduct, the ECOWAS Commission had taken some preliminary step to allow some of the materials come in by writing to the relevant custom authorities within the different regions to grant waivers to the contractor. Hence, there was that exemption at the initial stages when the first two was brought. At the third stage, they thought that they were going to follow the same mechanism by seeking some waivers. The ECOWAS Commission refused to actually grant those waivers because it was not contemplated in the original agreement. And this was based off on an internal advice that was given by a new legal advisor that had emerged, not the legal advisor that originally consummated the contract, that had the institutional memory of what led to those concessions in the first place. And from the advisory notes, whether the concessions were made because of the limited time the contract was to be executed, 15 months, otherwise the money were to go. So they made that concession despite the fact that there were no provisions that the contracting authority were going to take care of the tax exemptions to enable them clear their goods and install them appropriately. But the new legal advisor said, no, there is no such provision. We can't subject ourselves to such concessions, and you should go and deal with your stuff. That's refusal to make that subsequent concession led to demurrage, and the delivery period was affected. So we argued at the tribunal that they were unable to deliver within the milestone, and the last payment that they were supposed to be received by the contractor was not received owing to their own default. And the DDP, delivery posts that were supposed to be done, were also not done owing to the fact that they could not meet some of the obligations as contemplated in the original contract. Those cocktail of issues enveloped the project, and the project could not move a step further. No monies on the part of the contractor because the EU has withheld payment. The ECOWAS were not inclined to actually deploy additional funds from other budgetary provisions into the project. The project had about 6 million euros to be completed, which I believe, given the nature of that particular project and the objectives of same, that concession would have been made from the regional bodies to see how they could have completed that, but they failed to actually avoid that dispute or manage the contract effectively. The project failed. Tribunal came to a conclusion that indeed there was a default on the part of the claimants. The claimants should go and complete the project with respect to the items that they failed to deliver as at when due, despite receiving the second tranche of the payment, and the excuse of demurrage because of the inability to clear their goals, expecting that ECOWAS Commission would have assisted them in that regard, does not hold, despite the arguments of waiver by conduct. The last part was to the effect that the financing agreement between the ECOWAS Commission, despite being syndicated, but was independent from the supply contract. So the default on the part of the claimants does not impair the EU from keeping to its obligations under the financing agreement, because the financing agreement was to ensure that funds are available to the ECOWAS Commission for the projects that have been designated. So the default on the part of the contractor on a different project that is unconnected to the benefit of ECOWAS should not impair ECOWAS from the benefit of that original provisions as contained in the financing agreement. That navigation enabled the tribunal come to a conclusion that EU had an obligation to pay ECOWAS the monies, and ECOWAS should determine how the project should be completed, whether they intend to go with Mimitech Interglobal, the claimant in this instance case, or they proceed with a different contractor to complete the project in order to meet the underlying objective of that laudable infrastructure project. Now, I believe in my mind that there was a policy consideration on the part of the tribunal based on the demonstration by the lawyers on different sides, and were able to convince the tribunal that the tribunal should look beyond just the clear letters of the law, but the letters of this contract, but the spirits behind it. And the spirit was to the extent that the objectives as underlined by the various stakeholders at the time this project was conceptualized and leading to its the commissioning, the tribunal felt the need to see that parties are held to their respective bargains. And those bargains, including providing the requisite fundings that you set out for, despite the fact that the 14-day period had elapsed. And the pronouncements would force the hand of the European Union Parliament to bring forth the monies, and the monies will enable them see to the end of that project. Now, mind you, that project, that infrastructure project, cuts across telecommunications, it cuts across power generation because there were turbines to be installed, power distribution within the region, security infrastructure to be supplied, training of personnel, and a host of other projects within the ecosystem that was going to last for a period of 15 months expeditiously with the expertise that were required, and all that were deployed towards doing that. Now, because the contracting authority lacked the requisite framework on how they could avoid such disputes and made alternatives on how to pivot in the event that these predictable incidents expressly contained in the project occurred, they were unable to administer the project with the discipline that is required for dispute avoidance. And when it got to the stage of also resolving the disputes, there was still some level of lack of institutional framework that will enable them look beyond just the immediate disputes, but the project itself, and why it was conceptualized in the first place. That gave rise to the loophole that we're experiencing today. While the tribunal came up with a decision that was favorable to the ECOWAS Commission, both the contractor and the contracting authority filed challenge applications post-arbitration before national courts. The national courts made a decision affirming some parts of the award, and there is now 3 different appeals pending at the Court of Appeal on the propriety or otherwise of some of the pronouncements made by the tribunal. Now, what this dispute tends to underscore is the principles behind dispute avoidance. That the principle behind dispute avoidance goes beyond that our common phraseology of trying to avoid pitfalls. How do you administer the instruments that you've executed to enable you foresee and manage potential disputes that were clearly predictable? How do you also proceed to resolve the disputes in circumstances that they will arise without undermining the underlying objective why that project was conceptualized in the first place, is what this scenario paints for us. Till date, like I earlier stated, that project has not seen the light of day. The monies which were originally voted for were expended only 27 million euros. The rest of the funds that were supposed to complete just 30% of that project was sent back to the EU. And the claim that was being asserted was 6 million euros. The rest of the monies from the 13 million euros that was left was to be used for training local personnel that will take over the administration of the joint border posts, maintenance of the installations that would have been put in place, cater for distribution of the power that will be generated during that period and after that period, improve grid optimization for the regional member states that the joint border posts will directly affect, and a host of other ancillary work that would come through. None of it came to fruition, all because there was no clear structural framework on how to either avoid the dispute or to resolve the dispute. So the dispute resolution goes beyond inserting an arbitration clause or a mediation clause or a choice of court clause in the contract in terms of resolution. Dispute resolution is understanding what is the long-term benefit of this project. And if the long-term benefit is to have a joint border post that will curb insurgency, prevent terrorism infiltration, then the approach by especially the contracting authority would have been completely different. But they failed to actually implement that. Whilst the contract had a total of about 106 different clauses providing for various items, from the warranties to the indemnities to the false measures. And on paper, it looks good. In theory, it's something that law students and aspiring lawyers say, oh, this is a very well thought out contract, it's very comprehensive in its provision. But it goes beyond that. It is how you now discipline yourself in that administration of those fine prints as contained in the contract that will determine whether or not you can effectively avoid dispute to save the contract. Without that, the contract was a failure spectacularly on all the players involved, and there was no way that we would have been able to get past it. Assuming the Court of Appeal and the Supreme Court eventually resolves that, yes, the tribunal was right in its findings and conclusions that there was a breach on the part of the EU in the finance agreement, as well as there was a breach on the part of the contractor in the timelines for its implementation because the contract never envisaged a variation or an extension of time. The reality is that even if the monies are being paid by the EU back to the ECOWAS Commission, the cost of 13 million naira would not be realistic in completing that project again in 2026. or so soon thereafter, because of course, galloping inflation and other factors that are obvious on the face of it. So that failure to have that underlying mechanism created this mess that we're faced with. And this is a life issue that affects the entire African region. Of course, Nigerian practitioners will take note of that. I have actually curated an extensive paper, which I'm happy to actually share with the team, that will point to some of the basics on how navigating dispute avoidance mechanisms and dispute resolution in infrastructure projects will be useful to practitioners. But I must say that legal practitioners operating within the ecosystem must look towards adopting different mindsets from the traditional dispute resolution mechanisms that we have as litigators, as arbitrators arguing before tribunals of national courts, and indeed regional bodies. In infrastructure practice, the question is not merely how to win a dispute once it arises. The most important question is how to design contractual and procedural system to absorb conflict when they arise within and without destabilizing the project in itself. If you do not see the need to absorb the crisis and you find the need to just assert your right, despite the fact that you probably might be well within your rights as provided in the fine print of the contract, but looking at the underlying objectives, you probably might pivot differently to see that the contract survives. Now, I'll give you a typical example, which I earlier alluded to in this project. There was no requirement for payments of local taxes within the ECOWAS region and duties on the part of the contracting authority, because it was DDP, paid on delivery. The contractor was to take care of clearing of the goods. The contractor was to take care of paying the custom and excise duties that were required for the items that were brought in based on the assessments by the local authorities. But in the first two instances, when the initial goods were brought in, there was a need for some policy intervention on the part of the contracting authority, where the regional body had to speak to the different member states involved, from Nigeria to Benin to Ghana to Niger to Burkina Faso to Togo, to speak to their local authorities, and those ones made concession to grant them some waivers. Now, that concession was material towards saving the project, and it was a necessary contractual and procedural concession made within the context of that project. But 6 months down the line, when different mentalities came into the administration of the project, there were obvious infiltration for reasons best known to them, albeit political. They refused to actually advance that concession by member states again to enable this contractor deliver on that. Not minding the fact that you have a limited period within 15 months to utilize the funds that were available. And if the funds were not available, as of right, the EU will take it back. That was a major misgiven and ill-conceived advice that was done by the contracting authority at the time. And without that inherent understanding of the scope of no variation, no extension, and scope adjustments forming the underlying ordinary cycle of the project, you cannot appreciate how you can survive major infrastructure project. Now, there's a major infrastructure project within the telecom space of MTN acquiring a company known as IHC, run by some Lebanese who have been in this country for a while. The Lebanese, that's perhaps the only listed company in the New York Stock Exchange providing telecoms backup services for various multinational companies across board. And it's a 6.2 billion naira project. How that project that has various phases of approvals is being managed goes to the survival of that project, and how the advisors across board, from the optics, knowing that their very strong rules, even in the Johannesburg Stock Exchange and the New York Stock Exchange, that enjoins directors of these companies that are involved to make disclosures in the event of any issue that might imperil them or create integrity issues. The approach by our regulators and the advisors vis-a-vis those midwifery same will determine the survival of that project, as small as an investigating body calling in any of the directors or person of interest would also affect that. How you manage the media optics that will arise from that might give rise to the project being categorized as a project of immeasurable risk or irredeemable risk. And with that, even if you survive the approvals and the divestments and acquisition is concluded in a higher or lower cost, the ripple effect is that the stocks of those publicly listed companies in their various jurisdictions will be adversely affected because of the wrong optics that has midwife the management of the project all through the period. So, like Tolu earlier stated, big infrastructure projects of this nature, which will requires a number of factors: political stability, compliance posture on the parts of the players involved, regulatory bottlenecks, and the mindset of the regulators you're also interfacing with. I'll give you a typical example. A project of that nature where MTN is buying out IHC of $6.2 billion assets remaining. If there is the slightest indication that someone is undergoing some kind of investigation or is involved with a politically exposed person, and there is some kind of media optics to that effect, it has the potential to impair the entire project. So project advisors must envisage such realities on how to manage the narrative substantially to downplay the optics that will create unnecessary exposure, some unenvisaged, some envisaged, but it is not about trying to pursue a cause that you consider expedient. It is the big picture of safeguarding what the project stands to gain and what the country as a whole stands to gain. It is not enough to say EFC is inviting a number of persons, but how it will affect the subsequent events down the line. It's very material. So as practitioners trying to practice within that space, understanding beyond just the fine letters of providing contracts, litigating contracts by advancing arguments before national courts and tribunals, but the matrix that will keep you and survive the business is very crucial. Your compliance posture is dependent of risk averse, that because you're highly risk averse from that exposure, that just the sound of it would create irredeemable damages that you might not be able to come out of, and it might even result in insolvency of the company, should be the watchword. And that makes it a disciplined project. Like I earlier noted, that most infrastructure projects are turnkey, and those entrusted with managing same are those that understand the concept down to implementation and to the commissioning of same. And there is an wholesome responsibility, and by extension, wholesome liability that accrues with the obligations that they hold. And if at any point in the chain of events, there is a break that might not give rise to the sequence which will affect the objective, it affects the value chain across board. And that will create some kind of loose ends in the project. So I think I've been able to situate the fundamentals of understanding the concept of dispute avoidance to dispute resolution within the infrastructure space with the scenario I painted with the Mimitech Interglobal SRS project, which was very dear to our hearts. We tried as much as we can to manage same despite our late incursion into the dispute. But there were a number of factors that impaired the stakeholders from seeing that that project eventually comes to light. The Jonathan administration had a fair understanding of same because it was driven by Okonjo-Iweala, the Office of the National Security Advisor, on the part of the Nigerian state for the semi-cracker border. And there was regional support and state support to that effect. They were more than happy to actually provide additional funding on their part, but the disputes had gone to a stage where parties could not make reasonable compromise because of the hardened position taken by the European Union, and the contractor who had the original blueprint to see to the commission of the project was already pissed and had declared a dispute. And to that end, the Buhari administration could not manage it subsequently, and that's how we lost out on that. Even if the Nigerian government was happy to actually see to the conclusion of their own lot of that project, the Ghanaians were not inclined, the Togolese were not inclined, the Burkina Faso were not inclined, the Nigerians were not inclined. And the mischief which we sought to curb at the time still continues, and we still complain about insurgency, all because the initiative that was conceived at the time, supported by a different regional body, could not see the light of day owing to the failure to avoid the dispute and to resolve the dispute effectively without affecting the project. So I thank you all. I think I've spoken a lot. I would rather we have a Q&A for the residue of time left, and we can discuss this subject further within the limited time available. Thank you very much, Mr. Tolu.
Thank you so much, Nba-Slp. There's so much to unpack from everything you've just said. It has to be understood that there's a broader system to dispute avoidance and dispute resolution in the infrastructure sector, owning from contracts, design, financial architecture, policy, procedural choices, and enforcement strategies, even down to optics, like you mentioned, Lennox. There's so much to unpack. I don't want to hog the meeting. I would open up for questions now. Do we have any questions? I have my questions, but I want the meeting to ask their questions first. Maybe we'll have like minds.
Yeah, please. I'm happy to actually. Yes, I'm happy to actually. No, I'm happy to take questions. Like I said, I've curated an extensive paper which I'll be happy to share with the committee subsequently, and the members on the call can also have the advantage of having the paper for their subsequent use. And my contacts are equally there for them to actually ask questions if they are not able to actually ask questions within this session. So please, questions.
Okay. Nasir Tijani's hand is up. Sorry, can you unmute yourself and ask your question?
All right, thank you. Good afternoon. Thank you very much, Lennox. That was very illuminating and a lot of practical experience. My question is that most of these contracts, they are standard form. And then you have that, as you pointed out, the bargaining power is really not there. And standard form contracts, you have that inequality of bargaining power. So going forward, these disputes will invariably arise. And then when the parties are in a hurry, you only see the bright side. You sign without looking at the smaller prints. So what advice, what recommendation would you have? Because we'll have situations where these donor agencies will come. They will always flaunt this, and we're in a hurry to sign. Even where time is of the essence, time might not be made by the contractor that is not under our control. So what are recommendations? What recommendations will you give to lawyers, and maybe if we're in a position to advise recipients of these this, well, do you say assistance for infrastructural development? Thank you very much.
Thank you very much, Nasiru. That's a very good question. Tolu, do we take the questions first in batches, or I just answer right away?
For now, there are no other hands up, so I'm guessing we can just answer right away, sir.
Okay, thank you very much. And thank you, Mr. Tijani, for that question. It's a very good question and it's a very practical one. Like you rightly noted, which I had alluded to earlier, is that the bargaining power at the stage of consummating the contract is very crucial, and that determines most of the insertions into the contract. The clauses down to even the dispute resolution clauses is dependent on, they're asymmetric in nature. In this particular case, for the scenario that I painted, the entire contract was an EU format contract, and it was a civil law driven mentality, despite the fact that the provisional conditions provided for the choice of law within the context of the choice of law will be the law of the state of the contracting authority. And perhaps that was our saving grace in that provision. Otherwise, we were already forced to start engaging Belgium lawyers to assist us navigate the contentions that were put forth by the European parties in the course of the arbitral proceedings. Now, having a strong bargaining power is very crucial for a negotiation, and the nature of this project that I had stated for two regional bodies. There was no basis while the regional body as big as ECOWAS with 15 member states would make a concession of that nature because of $40 million, 40 million euros. There was no basis whatsoever, given the necessity of that project and how it affects the entire region. So to answer your questions pointedly, it's increasing your bargaining power so you're not vulnerable to accepting anything that is thrown at you. Now, for the lawyers too, they should be a background understanding of contract management. Not every lawyer has the understanding on contract management to the extent that you'll be able to advise at the stage of consummating the contract. With that depth of knowledge, there is a tendency that you're carried away by the fancy look of the provisions as contained, as against underscoring the underlying provisions and what the objectives of the provisions as containing therein would implicate subsequently. So my recommendation is, first, increase your bargaining power. Don't make yourself vulnerable. During the transition and of the power sector from what was known as NEPA and PHCN to the GENCOs and the DISCOs and the TCNs of today, when the power sector reform was being implemented in 2014, similar scenarios happened. All the FDIs that brought in funding to actually buy some of the GENCOs insisted that they would bring their foreign lawyers to Nigeria. The contracts were drafted by Herbert Smith. Herbert Smith had about 100 lawyers living in the Hilton. They will work from 8 a.m. to 5 p.m. and they'll start drinking beer in the whole of the Hilton. They fold their sleeves and they don't care because they were paid hourly rates. Meanwhile, they were advising on Nigerian assets to purchase public-owned assets in Nigeria and to be purchased by Nigerian companies substantially, funded by Nigerian banks. But all the templates that were brought in from England. The choice of law clauses were English. The venues of arbitration were ICC arbitration in Paris, Switzerland, London, and other parts of the world. But because we had very little bargaining power on the Nigerian contracting side, we considered to all those clauses, and all those disputes are somewhere around the world without the benefits of being litigated or resolved under Nigerian law and in the context of our local climate, despite the fact that the assets were in Nigeria. So increasing our bargaining power without allowing ourselves to the take it or leave it situation is the starting point at the stage of managing the dispute and avoiding it. The second aspect which you alluded to is that we're in a hurry. We need the money because it is free, more or less. We don't have any subsequent consideration to make. The EU is giving it to us as a aid, as an help, so they determine whatever they do. And that's the beginning of the problems that we have. For 40 million euros to have been a consideration why we shouldn't have joint border posts to protect our region from infiltration and curb insurgency in the magnitude that it has now dovetailed to, I think was poorly managed on the part of our region, and it's something we should avoid. So the federal government has an initiative called the FCAS, which was being projected by Aberdeen Commercial, a Nigerian Scots company that has assisted ministries and parastatals across board to implement what is called contract and project management in complex contracts. And those complex contracts have assisted us from the P&ID stage to the sunrise disputes that expose the Nigerian states to huge disputes and huge liability, save for the fact that fraud and illegality was invoked in the set-aside proceedings in England that gave rise to that liability that the Nigerian government would have been faced with if we were not lucky to have set aside. But you can understand that the foundation of the P&ID contract was what exposed us to that liability, because we just signed things without knowing the implications of what they will be. So involving professionals who will understand the factual matrix and structure it in such a way that the predictability will be unequivocal is very important, and it will be sector-based. People in telecoms understand the matrix of telecommunications. Those in power generation and distribution understands that. Those in other areas like fiber optics, engineering, finance, fuse that consortium together. So you can have, it is not enough to say a ministry is about to go into a project finance or an infrastructure project and you throw it to an in-house lawyer within the ministry. He might be intelligent in his civil litigation, he might be intelligent in his criminal litigation, he might be well knowledgeable in this courtroom practice, but understanding the matrix on how to envisage potential exposures and disputes is what is very crucial. So that's my advice, that infuse professionals who understand the factual nuances of these things and also increase bargaining power at the stage of contracting is very crucial to curb these issues from an anticipatory perspective.
Thank you so much, Neil and Silk. I have a question in the chat room.
Yes, please.
It's too long. How do parties to a contract envisage issues of a specific nature as opposed to those standard clauses known to contract? Which I think is a two-part question. Should we draft a general clause focusing on the objective of the project to say, quotes, open quotes, no legal obligation, close quotes, on any party seeking same should affect the objective of the project? Therefore, parties are expected to be ready to compromise to ensure the project is delivered. Would that not be increasing the stakeholders of such projects? Sorry, Mr. Olajide Onosanya, please, can you ask your question in person without the type, because it seems a bit too long, and you'll be able to explain your perspective very clearly. Mr. Jide Onosanya, are you still with us? Mr. Olajide? Okay, I think he stepped out. The question is a bit long, but let me just read the first part of it again. How do parties to a contract envisage issues of a specific nature as opposed to those standard clauses known to contract?
Okay, for starters, you must first understand the underlying objective of the contract in order for you to be able to situate it within the context of specific clauses. And once you have that understanding at the back of your mind, that this is what we intend to achieve on the long run, there's a need to now contemplate intervening events that might impair the original projections. And those intervening events is what will give rise to how you would situate them in terms of contractual provisions. Now, there are boilerplate clauses which are contained in standard infrastructure contracts that you might want to look into. But like I said, there's no hard and fast rule. It's not cast in stone. Each factual matrix of particular contracts would enable you situate relevant provisions to cater for this. For example, issues of concessions could be envisaged reasonably, even if it's subject to various interpretations by different parties. You could set out in specific regions where specific projects where you know how things are done. For example, in telecommunications, where fibers are installed across different states and different regions that might have different legal framework on local content and other factors. There is a need for an open-ended clause that will allow for scope adjustment as well as variation, including extension. And in infrastructure projects, there is always a need from a strong bargaining perspective for the contractor to always create room for those variations, reasonable variations that might result from intervening events. Sometimes your force majeure clauses might contemplate this, but force majeure clauses couched in a vague, open-ended fashion might not be specific. So in talking about specific contracts, you tie them to the nature of the infrastructure under reference. So what is expected in telecoms will be different from what is expected in a gas development turbine infrastructure project or a power project or a construction project. There are different nuances to these various projects, but having a broad understanding of what the objectives are, the things that you might encounter from a technical perspective, and the likely regime change or policy change or instability or policy decisions that might affect same will give an idea of what you can. But it is practically impossible for you to envisage everything in most cases because some unenvisaged events will occur. And those boilerplate clauses that creates room for variation for reasonable intervening factors might cater for those things. And it depends on judicial interpretation or tribunal interpretation as the case may be. So having those specifics is dependent on the nuances of the particular project. I don't know if that answers your question, Mr. Olajide, or you want me to actually. Hello, Mr. Tolu, are you there?
Oh, yes. My apologies. I was muted. So he
Okay.
has responded. He said that you answered this question. Thank you very much, Leonard Silk.
Okay. Thank you.
Do we have any other questions from the meeting? Okay, I have a question.
Yes, please.
I remember when we were working on the Mimitek arbitration, and
Yes.
like you've rightly mentioned, we lamented a lot about the loss of opportunity as regards the protection of our border posts and collaboration with our neighboring countries. So my question is, based on your experience, what are the practical signs that you would say tells when a party or a lawyer is reflexively triggering dispute resolution, be it arbitration or litigation?
That's a very good question. A very, very good question. I mean, most times it is when the lawyer or a party does not align with the objectives of the project that has given rise to that infrastructure development in the first place. So it is not enough to yank an external counsel into your dispute to advise at some stage when he was not involved or he has not been made to understand what animated this project in the first place. And there could be a complete misalignment of values. And for us, typical dispute resolution lawyers, well, there's a dispute. We want to invoice and we want to get our fee. It's either we win or we lose, but our own is to present our client's case. Now, that might be strategically and effectively right for the purpose of winning or losing. But in managing infrastructure disputes with an understanding of what the objectives are, it goes beyond winning or losing. It is about how to achieve the underlying objective. And if that is the goal, your approach and mentality will be completely different on how you approach these things, how you interrogate the subjects, how you make concession and advance your position. Until there is that clear understanding, navigating infrastructure disputes would never give us the results that we expect in terms of development as a region or development as a country. If it is all about going to file objections and pleadings and all kinds of things, we will miss the point. So at the stage of getting to manage a dispute after it has been triggered by any of the parties is to take a chill pill and say, okay, how do we deal with this issue without creating exposures or liability for ourselves, at the same time finding the right balance to also see that the project is eventually completed and the goals that drove it ab initio are achieved. That's when we might be able to have an alignment of objectives and see how that can be done. So those who consummated the project, like I said, they are often turnkey, should be able to have a clear objective. Like one of the questions that we asked, is there a necessity to have an objective in the contract? Yes, sometimes you might do it as a preamble, that the objective of the contract is to see that we curb insurgency in this region and everything, there must be reasonable concessions to be made to ensure that this is done. And like I said, the Jonathan government tried to make the concession within the limits of their powers, but because it goes beyond just one member state, it was a regional thing, and there was no way they could have bifurcated those contracts. It became a problem. When it got to the lawyers in-house, the lawyers who originally advised on the contract, even if they too didn't do a very good job, in my opinion, were still unable to see the need for these new people to now say, okay, as opposed to allowing EU take their position as to set off, why don't we look for a way to complete this project and see how we can advance a different request without the monies going back? Because the 17 million euros that were enough to complete the project was still within reach 2 months after the notice of arbitration was issued. At that stage, I believe strongly that the last concentration or the parties' concentration was about resolving the dispute or litigating the matter or going to arbitration, as against saying, okay, let us ensure that we don't lose the money and we make concessions to ensure that either this contractor or another contractor finishes the project, and we'll look for a way to set it off after the project has been completed, which is still practical and is still doable. So at the stage of completion, before the commissioning or at the stage of commissioning, you could always bring an action for the default that occurred for monies either received or to claim some, but the projects are still being sustained. So to your question directly, I think understanding the trajectory of what animated that project in the first place would give a sense of someone trying to advance an ulterior motive by triggering a dispute for some self-seeking purpose, not taking into cognizance what the project stands to benefit the larger interest and what the objectives were drawn up for ab initio. The optics alone is bad. I understand that since after the Mimitech project, the European Union has not voted any monies beyond 10 million euros for Africa infrastructure anymore. So what they do is to just provide aids for the purpose of taking care of disease and education across board, not for infrastructure because of the experience they had with the joint border post, which was supposed to launch their local companies, creates a flag for European advertisements, creates some kind of local content training with European incursion into the system, and continue to maintain that regional relationship between the Francophone bloc and the EU. So since then, nothing has been done up till now because the bargaining power was poor, as well as the appreciation of when a dispute is being wrongly triggered was not taken into cognizance. So I don't know if I've been able to answer your question, Mr. Derinde.
Definitely, sir. Thank you, sir. We have a question, Mr. Jeffrey. Mr. Jeffrey, you have a question.
Can you hear me, sir?
Yes, we can hear you.
All right, thank you very much. Good afternoon. Yeah, let me quickly ask my question. Apart from invoking the set-top clause, could the EU not sue for the default by Mimetech?
Yes, they would have been able to, but there were complications at the disputes resolution stage, which I had explained earlier, but I'll just reiterate. Now, the reason why they inserted the set-off clause was to avoid going through the route of litigation by suing. The monies are with them. You've defaulted. They just collect it. It saves them cost. It saves them resources. It saves them everything by going through a court process or an arbitral process to get the monies they can easily just get. The monies are in their custody. They're the ones to pay you. Now you've committed a default somewhere else, and the EDF, the European Development Fund's charter and regulations allows them to exercise that right. That right was also invoked into the tripartite agreement known as the Contract for Supply and Installation of the Joint Border Post. So they easily just exercised that right without recourse to the ECOWAS. And they did that conveniently. They didn't need to go through a longer route to do that. Whilst they had an option to also sue, but the essence of suing was to give them their money. And the project is not to their benefit, so they didn't care. That's where the regional body in Africa, ECOWAS, failed to take cognizance of that particular provision and the far-reaching effect. So yes, they could have sued, but why would they have when they have an easier way of getting their monies and seeking the revenue they want? Yes.
Thank you, Mr. Jeffrey.
Thank you, Doctor.
Do we have any other questions? Okay. Thank you again, Leonard Silk. Today's session has been very illuminating. It reinforces a central lesson, which is that infrastructure disputes do not begin in the courtroom. As a matter of fact, as you have elucidated, it starts even before it is predictable, rather, even before the contract drafting is concluded. Things like financial assumptions, regulatory expectations, politics, optics, they have to come into play as well as the objectives of the projects. So on that note, I would like to thank Mr. Michael Jonathan Numa, SAN, for a truly enriching session, and to thank all participants for joining us today. Thank you very much, Leonard Silk.
Thank you.
For those of us that are not members of the section, please let us join if we can. The conference is coming up soon. If we can attend as well, it will be nice to hang out again as lawyers. So thank you, everybody. Thank you again, Leonard Silk. I don't know if the leader of the section is here.
Yes, thank you so much, everyone, for joining us again on another episode of our Nba-Slp TMT webinar series.
Sorry, Damilola, I don't know if it's just me. We're struggling to hear you.
Oh, okay. I guess it's my audio. I guess it's my audio. So thank you all for joining. Yes, thank you all for joining us today. So the slides will be shared via email as soon as we receive it from our speaker. Thank you so much. And please don't forget to register for the Nba-Slp conference and enjoy the rest of your day. Thank you.
Thank you, everyone. Thank you to all the participants.
Thank you, Mike.
Thank you, Jeffrey.
Thank you so much. Thank you, Mr. Noma. Thank you so much.
Thank you, Damilola. The pleasure was all mine.